to The Presumption. Hey, Jim. Hey, Matt.
Hey.
Hey, Sarah.
You guys, I'm sorry I shit you up today with LA traffic. And anyway, I'm glad that we're all here together. And we've been having a lot of, I think you guys probably saw on Twitter and in the emails, we've gotten a lot of, interest in talking about the Idaho 4 quadruple homicide, the case against Bryan Kohberger. And I'm excited to do this here because even though I've spoken about it on other platforms, Jim and I have not really dug deep into this. So we plan on, obviously covering this extensively. And if the case goes to trial, we'll unpack the trial too. But today, there was a set of questions that came through that I promised that we would address. And as I was looking, Matt, to kind of send them to you to read them off, I realized that Jim and I, it's already in our agenda. So what we're going to talk about, hopefully will answer all the questions that we've gotten so far.
Having said that, keep those questions coming via Twitter at The Presumption, or you can email us at thepresumptionpod@gmail.com. We definitely want to get to all of your guys' questions. So just throwing that out there.
So the prosecution, the state of Idaho, filed a pretty robust motion to, the defense, Bryan Kohberger's defense, filed a pretty robust motion to compel discovery under Rule 16 of the Idaho rules. It's being heard next week. And so ahead of that motion hearing, the state has now filed a motion for a protective order specific to the IGG materials, the Investigative Genetic Genealogy materials that the defense wants and believes that to some extent is exculpatory. And I read this and I thought, okay, there's some compelling arguments, but a lot of bullshit. Jim, what was your reaction?
Yeah, I mean, it's same. I am, and we'll get into it. And we have a really good guest to dig deeper into this genetic genealogy, I guess, topic, platform, science, whatever you want to call it. But what we learned a lot of blockbuster information from the state's response to the motion to compel. We learned a lot of information about the DNA analysis, the standard DNA analysis. We've learned that the FBI assisted Idaho State Police with the genetic genealogy investigation. And we've also learned that the FBI has just, deleted their work product because they don't want to share it, which I find, I just find very, very troubling. And
what is that? They deleted what?
Yeah, Matt. So this whole genetic genealogy field, I think the FBI does not want the general public to know how much they know about the general public. Honestly, I think that's really the issue. And so they are doing their level best to hide it from us. And just as a
can I say something to that point? Go ahead.
Sure. Go ahead. Go ahead. Yeah, go ahead.
Yeah. So there was an interesting article that I'll tweet out for everyone to see in Wired about how the FBI has local law enforcement agencies that enlist its help or use these. It's a digital footprint type of device that the FBI uses. When they enlist that service from the FBI makes the local law enforcement agency sign an NDA that they will never produce the information about this stuff to the defendant or in the case. And I'm starting to wonder, and I really want us to dig deeper into this, whether this IGG material falls under some sort of a NDA that the FBI has with local law enforcement when local law enforcement uses them as an investigative source, or agency in a case. I'll share that article with everybody. But you know what? Matt, they were looking at the investigative part of this. There's two arms to IGG, which our guest will explain, but there's the scientific arm that essentially processes the DNA sample to get what's called a SNP, a SNP. And then that SNP then gets used and put into databases to investigate the genealogy and create a family tree. And what I feel is bullshit, like I said, in this motion for protective order, is that it's very clear that the prosecution is trying to divorce the SNP generation from the family tree investigative part. In other words, saying that because the SNP was done by this Othram lab in Texas and then the family tree was done by FBI, this is not a science, and therefore under Rule 16, we are not under any duty to present to you any reports or any memos or notes or anything that pertains to this investigation around the genetic genealogy. So it's really, I don't know how much of it is essentially the FBI not wanting to turn it over, like Jim, you're saying, and how much of it is that Idaho is trying to hide the ball. I don't know if Idaho has some sort of an agreement with the FBI not to produce it. And what happens, Jim, if the defense now subpoenas it from the FBI because they can't get it from the state?
Yeah, I mean, so I think let's back up and what we did learn through the state's motion for protective order is a lot of information about DNA that has been developed in the case. And, interestingly, there's a gag order, and the gag order has prevented, law enforcement and the defense from addressing these factual, portions of their investigation. But, now the state has filed this robust response laying out their DNA evidence. And, that's something that, that's how you get around a gag order. You put it in the court record, and that's what the state has done. And so what we've learned is there's this sheath for a knife that was now found under it was under one of the victim's bodies, partially. And in the snap on the sheath, there was a single source DNA, which means it was one person's DNA. And the Idaho State Lab did traditional DNA analysis of that, and it's called STR, short tandem repeats. And I don't want to get into details, but it's what state criminal labs do, and they put that DNA STR analysis in the CODIS, which is the national database, and it came back without a hit. And so then Idaho sent the DNA sample or a copy of the sample to this lab in Texas. And then they did the SNP analysis, which is, which only private labs are doing this. State labs and FBI labs are not doing it. And so then this Othram lab started to do the genealogy work using their results from the SNP analysis and comparing it to whatever database. And Idaho said, whoa, stop. We want to give this to the FBI.
And that's a question of why too, right? I mean, if I represented Kohberger, I would want to know whether this is just routine that sometimes they want the FBI to do that portion of it, or did they find out something about Othram? Because I've heard things about Othram from people that we work with, DNA experts, who say that, there's some issues. And in fact, somebody recently, I think the CEO or somebody left, and it has not been under really good I should say terms. There's something up with Othram that is worth looking into. And I would imagine that Kohberger's public defenders are going to look carefully at why, initially Othram was supposed to do all of it. And then they said, oh no, it's got to go to that. But regardless, it is science.
Well, and so what you have is Othram and the other private companies. They're essentially two databases where people who put their DNA in for genealogy testing and research, what have you, that where the participants under their agreement understand and agree that their DNA can be used for law enforcement investigative purposes. Mm-hmm. The big ones, 23andMe and I forgot the other one,
Ancestry.com.
They do not permit, under their service agreement, they do not allow the DNA to be shared with law enforcement. Now, what we're reading in this robust response from Idaho, what I read and what it appears to me is that the FBI is running the SNP DNA through all the databases and through every database, that's not available to private industry. And you wonder how the FBI has access to that. And is the FBI have their own account at 23andMe, or some agent has an account at 23andMe and just sends this DNA through there. Who knows what's going on? And I think those are answered questions.
But that's the problem, is that you can't keep an investigative technique a secret. The defendant has a right to know how he was investigated, starting with how he was identified. Some of the questions, Jim, well, all the questions really, are really around the arguments in the state's filing, which is, I sort of, kind of had to outline it. There are 5 things that they're saying. They're saying that it's not exculpatory, and in fact, it's incriminating. It's not material to the preparation of the defense. We're not using it at trial, so you don't get to have it either. I hate when they say that. It doesn't belong to Kohberger. Fair enough. And it's not a science. Now, I just want to briefly, because I want to make sure we answer everybody's questions, just hit on the points that I sort of extracted from this. The fact that it's not exculpatory, look, the defense should be able to challenge the reliability of the SNP by the Texas, lab. And that's why they need to know the investigative method and the technique. So it's relevant, and it could potentially be exculpatory. Not material to the defense. I lose my shit. I don't know about you, but when the prosecution says that, or the court says that it's not material, well, how do you know? I mean, you could rule on that later in terms of admissibility at trial, but to tell me that something's not material at this early stage and that I don't get to even see it is really just such a bullshit way to close the door on access. Then, we're not using it at trial, and it wasn't even used as a basis for probable cause.
But you'll see in their response, they reserve the right to use it at trial, and they say, "Well, if you choose to use it, then we'll give it to you." Which is
but then that's too late, because the defense doesn't get to do its own independent consultations with experts or hiring the right expert and all that. The fact that we're not using it at trial, fair enough, but there's other criteria under Rule 16 where they have to, they're obligated to turn over discovery. That's a wash. And then it doesn't belong to him because he essentially abandoned his DNA and the sheath at the crime scene. I guess that's fine too. But where, Jim, I think the defense has the strongest argument in response to this motion is that they say it's not a science, because one of the reasons you turn over discovery in Idaho is that it relates to a scientific method, that it's a scientific report. So they're saying a couple things. They're saying that that FBI just did the family tree, was not doing the SNP extraction or whatever you call it. And so this isn't science. No, you don't get to farm something out to another lab or another agency and then divorce it and separate out the real processing part from the investigative part and then say it's not science. It is science. And they're saying that, there was no reports, and maybe the FBI had some notes or something, but there's no reports. How many times have you, Jim, encountered the argument that, notes, memoranda, all of those things written on a napkin by an agent is a report?
Right. And
does it have to say report at the top?
No, it doesn't have to say report at the top or at the bottom or anywhere in the document to be a report, clearly.
And so I analogize this to fruit of the poisonous tree. This is like fruit of, the DNA tree, right? It's the same concept.
So
if Kohberger is identified through this process of IgG, then that is fruit of the DNA tree, and he is entitled to know the investigative technique and the science behind this and what was done.
If the FBI engaged in, what a court might rule down the road as illegal conduct by accessing other databases under false pretenses, I don't know that happened, but that's certainly worth looking into. Then, maybe the whole DNA results are thrown out of the case. I mean, I certainly would be arguing that if I was the defense. It
wouldn't be the DNA, right? It would be his identification has to get thrown out. His identification was the fruit of IgG.
Well, yeah. So what happened was they got the snip, they gave it the FBI. The FBI then did this
Right.
genealogy tree,
And they
and,
identified him.
and,
He
and they
he was a
identified
hit.
Kohberger, and then they went to his house and did a garbage
Right.
search to get DNA, and that matched his dad, and they used that to get an arrest warrant. And then they got a buccal swab, which is a DNA swab from Kohberger. And now, what we see in this document is it's a statistical match that the single source DNA found on the snap on the knife sheath is a statistical match to Kohberger.
So I have a question
Sarah,
that somebody
does that
asked.
mean, Sarah, does that mean he did it? Because
No. Why? Because
why?
it's
Yeah, why?
touch DNA.
Is that like flag football? What are you talking about?
Is that like somebody just took the sheath and just kind of like rubbed it on him when he was walking by and then left it there? Like, how does that work?
No, Jim, you know this from the Murdaugh trial, obviously, and a lot of other trials, but it came up in Murdaugh too with his, Paul's DNA or whatever on his shirt. I mean, obviously he was living in the same house. It's a different story, but touch and transfer DNA have reliability problems. They're not like profiling DNA. And so how and when Kohberger's DNA ended up on that snap matters, and is actually something that the defense will really hit on in a trial in this case. And contamination, you brought this up, Jim, is another issue, right?
Yeah. Oh, sure. So with the DNA results, you've got two questions. When was the DNA put on the snap, and was it well before? I mean, they're in Idaho in the wintertime, for God's sakes. And it's cold, I suspect, in Idaho. It's cold in South Carolina in the wintertime. And DNA lasts a long time in cold weather. I mean, they store it in cold, not really freezers, but refrigerators. And they preserve it. So that DNA could have been put on that snap, well before the murders, months before the murders. That knife, if it was used in the murders, could have been obtained by the perpetrator from many different ways. Kohberger could have lost the knife and it was found. He could have, he could know the murderer. I mean, right? That doesn't make him the murderer. He can know who that person is. But anyway, so accepting that the DNA is accurate, but again, and I hate to hark back to OJ because that was so long ago, but that is what Barry Scheck and his team were able to do to create doubt as to whether there was contamination in the lab, because you can have cross contamination in the lab when you're dealing with touch DNA. Yeah. And so, what you're talking about is, the buccal swab is a match, but did they cross contaminate the samples in the Idaho State lab? We know the FBI has had some really issues in their FBI lab over the years. I assume they've cleaned them up.
Well, what about just that's cross contamination in the lab, and then there's also the crime scene. The crime scene here. The police were not called for like 8 hours after, and it appears, because this was a party house, and it appeared very clean. So when the police arrived, the only items of forensic evidence that they were able to collect that they saw was this knife sheath and one latent footprint. So what, the guy was hopping, or he had one leg? I mean, the woman, the roommate that saw him didn't say he had one leg. She said he had bushy eyebrows. But, it's very bizarre because, like in your case, Jim, where we're like, what, Mr. Clean, what? Like there's no evidence, right? There's no evidence. And so with stabbing 4 people is a pretty gory, bloody, crime scene. This house was way too clean for that. And it's always bothered me. Like, it took 8 hours, even if we buy the story that this girl was in shock and paralyzed and just went back to bed, fine, but that house could not have been as clean as the police found it the next day, with just one knife sheath, with a little itty bitty drop of blood, and then a one latent footprint. So that's also weird. What about, Jim, the another big piece of bullshit, which is the informant? They say that the genealogical service is an informant, and that the hundreds of people, relatives of Kohberger, that came up are indirect informants. Informants are human beings, and informants are not genealogical services, and they actually get paid to eventually come and testify against a defendant. These are people that are using a consumer product and actually paying to find their relatives. What is your thought about the analogy to an informant?
I mean, I think it's ludicrous. I don't think it is analogous. I mean, for the reasons you say, Sarah. I mean, we all deal with informants. And frankly, if the case goes to trial, informants get unmasked because they are really the start of the investigation. And so that's not a bulletproof. Understand informants are protected for personal safety. I mean, in criminal cases, drug cases, significant, violent crime cases. I mean, there's a significant risk that an informant, some harm could come to them. I got to tell you, I had a really significant drug case many years ago. And then there was an informant who was a key witness. Informant never made it to trial. He was murdered. My client was in jail at the time, but guess what happened to that case? It went away. And so there's understandably reasons to protect the informant now.
But these people. These people went on a public database. They knew that they're going and putting their DNA on a public database. They paid to do so that it could be accessed publicly. That's why they can't be viewed as an informant. They are using a consumer service, I should say, paying for it, that is public. And so that's really the plea that the state is making to the court, is that, first of all, none of this is subject to disclosure because it's not under Rule 16. And even if you disagree with us, you need to have an in-camera and realize that they're informants. And under a Supreme Court case, they deserve the protection that you just said, Jim. But they're not informants. And one other point about that is that, if this is really that kind of database that law enforcement gets to use and whatnot, and let's say they're using it legitimately, they need to have a dedicated database for this, in my opinion. If they're trying to, call these people informants and say they only are on here to catch killers, then create a new database that law enforcement has access to that people can just voluntarily submit their DNA into. Right?
Yeah, I totally agree. Totally agree. Let me get back.
What about the idea that the notes, the FBI notes, we don't have them. The FBI made some notes, so we don't have to turn them over. What about that?
And they said they destroyed a lot of their stuff. I mean, it's incredible. It's incredible. But
that's the part that's crazy to me. Anytime you hear that the FBI or any of these, public offices have destroyed the information or lost the information, you're losing trust in the public too. Like, how are we supposed to trust these services if all these important things are just kind of going by the wayside?
So somebody was asking, honing in on this FBI thing. There's two things to know about this. One is the fact that a law enforcement agency or the prosecution does not itself have something that's subject to disclosure in their possession does not release them from the obligation of getting it from an agency they farm the work out to and produce it. You can't shield discovery just because you're farming it out. Otherwise, they just farm everything out and be like, we don't have anything, right? That's number one. And number two, notes and memos and anything could satisfy a report. A report doesn't have to say report at the top. The last thing, Jim, that I think folks want to know is, no, I think we covered it all. Do we have anything that we haven't addressed, Matt?
Yeah, no, I've got something that really is, it chaps me. And it is this whole, so we've got this case, there's a gag order. Yeah. Lawyers can't talk about it. Now, what we have is the state filed what I refer to as the turd in the punch bowl. They filed this response, and in that they say that there is a statistical match of the defendant's DNA to the sheath on the button.
Yeah, whoop-de-doo.
And because of that, the public media and people are reading that and it goes, done, he's guilty. His DNA was found at the murder scene. The defense lawyers don't get an opportunity to give an interview to the press to say, hey, even if that's the case, that doesn't mean anything because that DNA on that button could have been put there months in advance. And we don't, that doesn't put him at the crime scene, but they're gagged and they can't say that. And I dealt with this in a lot of cases. And the most recent case is the Murdoch case, where things get filed and you can't respond publicly. And it is, so that's one of the reasons we're doing this podcast, is so that we can give voice to the defense to say the things that these defense lawyers are gagged and they can't say. And so my point
That's a good point. That's a good point.
I mean, it's 1,000%, why I'm sitting here talking about this, because those defense lawyers, because of that gag order, can't say, well, so what? That doesn't mean he was at the murder scene. He murdered them. That just means at one point in time, if you accept the evidence, that he touched that snap. It doesn't say when he touched it, why he touched it, and who had it at the time of the murders.
And, one thing I want to end with is, and obviously this is a circumstantial case, so there's a lot of other stuff, digital footprint, et cetera, that they also have. But DNA is a big, huge piece of scientific evidence. IgG is newer, obviously, but it is key. And the problem I think we have, Jim, is that because of the newness, we don't have a higher court type of binding ruling or authority on how this discovery of IgG should be dealt with. So in Idaho, it's a case of first impression. It's never come up. They have attached a case from, I think, El Dorado County or something, California, which is a superior court ruling. It's like a lower court, trial court ruling. It's really just what one judge in California thought of the issue. And that's a problem. I think at some point, this issue has to be challenged. It has to go up through the appellate process and eventually to the Supreme Court. So we have some solid guidance, because it touches on Fourth Amendment. It touches on Sixth Amendment, right to a fair trial, to put on a defense. It really has a lot of constitutional, issues in it.
So very, very important issues. This is a fascinating case. We'll be following it, and we got a great guest coming up. Before we go there, I just, I'm on here for the Southern flavor. I just want to know, turd in the punch bowl, Matt, is that something that you say out in Texas or California?
I have definitely heard that before.
What is that?
I would never want to see it in my life, but it's the statement that ruins everything. Just it's pretty literal. I feel like
turd in a punch bowl.
Like you're at a party and someone's pooped in the punch bowl. You don't want to drink that. You don't want that. Yeah.
You got to get it out. Someone's got to
exactly.
get it out. Yeah, that's right.
I thought I was bad saying I shit you up with traffic today. Anyway, stay with us. We'll be back with a great guest on all things IgG. Welcome back to The Presumption with Jim Griffin, Matt, and me. And today we are joined by CeCe Moore, the leading authority on investigative genetic genealogy, also known as IgG, which sounds like something out of a fertility clinic, but it's actually DNA related. CeCe, welcome to the show.
Thanks for having me. I'll just note that it's also called forensic genetic genealogy and forensic investigative genetic genealogy, but I do prefer the investigative GG.
Yeah, IgG.
You do the forensic investigative, then you got FIG, though. I feel like that might be a little easier for people to remember.
That is what it seems to be morphing toward. But just so the audience understands, those are all the same thing, same technique. Yeah. We just haven't settled on the term yet.
So for those of you who don't know CeCe, as I said, she's a leading authority on IgG through collaboration with hundreds of investigative agencies across all 50 states, as well as other countries. She has led the Parabon Genetic Genealogy team to the unparalleled record of over 300 successful identifications of violent criminal suspects and unidentified decedents since 2018. That's like one per week, CeCe, right? Average?
And we've stayed pretty consistent with that from the very beginning.
And CeCe's work with law enforcement has led to cases where the suspect was identified through IGG and has led to 70 convictions of violent criminals so far. Now, what stood out to me about that part of your background, CeCe, is that, or your record, I should say, is that typically IGG is used or has been used in cold cases. And I thought 70 convictions out of cold cases is a lot, right?
Yes, but they're not all cold cases. So
Okay.
a lot of people believe that the Kohberger case is the first time it was used in an active investigation. But I actually worked with Detective Josh Wilson out of St. George, Utah, on a rape and assault of an elderly woman in their community way back in the summer of 2018. And that rapist actually pled guilty. And he was the first person who was identified through investigative genetic genealogy in an active investigation.
And CeCe's also been on PBS and ABC, where she's had a show. Earlier this year, you probably saw her a lot on news shows just following Bryan Kohberger's arrest in Pennsylvania. Just a few questions before I turn it over to Jim. Jim is extremely skeptical. I'm very curious, and Matt is hesitant. Okay, just so you're prepared. And we have a lot to learn collectively from you. So
I've dealt with a lot of objections and privacy questions and things like that over the decade plus that I've been doing.
Well, yeah, and I'll be honest. Obviously, this is important. I mean, I don't think Jim has either. We've not had a genetic genealogy type of case where it's been the identification tool in our cases. So of course I want to use this to prepare myself for possible cross-examination in the future. But it's obviously something that is now more, like you said, prevalent in these active investigations, and important to know how it works, because when you talk to some traditional DNA experts, they say it's junk science. They say it's unreliable. It's like Ancestry and Me. And obviously there's more to it that you're going to educate us on. What is the difference between what you do in the genetic genealogy field and a traditional DNA science, I should say?
So traditionally, law enforcement has used a STR profile. That's a short tandem repeat, and there's 20 genetic markers typically in those profiles. That is what's court admissible. That is what you use in the law enforcement databases when you're looking for that exact match, or if you're doing a familial search in the law enforcement databases where you're looking for a first-degree relative, parent, child, or a full sibling. Mm-hmm. Genetic genealogy is performed on voluntarily provided profiles. And that's what's very different, because with STR testing and the law enforcement databases, those are compelled DNA profiles. And so there's certain laws that would apply to that. In genetic genealogy, we're using a different type of genetic marker. It's called a SNP, SNP, single nucleotide polymorphism. And we look at almost 1 million of those across the genome in order to create the file that is then uploaded to the two databases that have agreed to work with law enforcement. And those are GEDmatch and Family Tree DNA. So everyone in those databases has been notified and been given the opportunity to opt in or opt out of their DNA being used for this purpose. And those are the two smallest databases in the field. So there's over 40 million people who have taken direct-to-consumer DNA tests. And there's a big misconception that law enforcement can compare against all of those. But Ancestry DNA, 23andMe...
So it's only if they opt in.
Yes, but...
Well, why would they opt in? Why would anybody opt in?
Well, let me quickly make the point that we can't use Ancestry DNA, 23andMe, or MyHeritage because they have terms of service that bar law enforcement's use. So it's really important for people to understand that. Now, why would people opt in? Because they think it is a good thing that violent criminals are being identified and that unidentified human remains are also being identified, and resolution and answers are being given to these families. And so these are people that have clearly thought this through, and it's something they want to actively support.
Well, say, CeCe, on opting in, I mean, I may have read something incorrectly, but what I read is that Family Tree DNA, they opt you in automatically. And so
that's right. I was careful with my wording. I said you're given the opportunity to opt in or out, which is true, but the two databases handle it differently. At GEDmatch, you have to actively opt in. You have to check a box that says police. At Family Tree DNA, all U.S. residents are automatically opted in, and they have the opportunity to opt themselves out. So it's a different system.
That's consistent with what I've read. Is the genealogy-based DNA, is it all mitochondrial DNA as opposed to?
It's autosomal DNA, which is the type of DNA you inherit from all of your ancestral lines. We can also see any shared X chromosome DNA, which can be useful if we're trying to identify a male, since at X DNA only comes through his mom's side. So it's almost exclusively autosomal DNA. There are times where we might look at the mitochondrial DNA or the Y DNA to see if it's consistent between two people, but the vast majority of our work is done with the autosomal DNA analysis.
And one of the other things I've read is that the genealogy DNA lab director at the FBI, for example, advocates not disclosing the use of this science in court, that they relied upon it to identify a suspect, perhaps like in the Kohberger case, but they're taking great pains to hide the fact that they relied upon this technology. Why is that?
Oh, to my knowledge, that is a mischaracterization of the policy. They don't want it being brought into court because it's not evidence against somebody. It doesn't prove anyone committed a crime. It's just considered a tip or a lead generator. And so they don't use it in their warrants. So to my understanding, the FBI has been recommending that it's not used in a warrant. It's never used as the basis for an arrest, to charge anyone, or to compel DNA collection. So I've never heard what you're saying, that they say not to reveal it at all. They just want to keep it out of court.
Well, explain how it can be used as a tip. I don't understand that.
It's the same as if I called a name into Crime Stoppers and they need to do the full investigation. They need to determine whether that is a true person of interest. And if they believe it is, they need to collect DNA, which typically they do surreptitiously, because they have to get that one-to-one match to their court admissible STR DNA profile. They cannot.
And I think we'll talk about that in the context of Kohberger, but you provided us with a chart that essentially you use to explain how genetic genealogy testing or investigation works. And Matt, if we could put up that chart for CeCe to walk us through the science, essentially. So you get a sample DNA, for example, on the snap button of the knife sheath that was between two of the victims in the home on Kings Road in the Kohberger case. You get that sample, and then what happens next in this process?
So it needs to go to a third-party lab because there are no crime labs that currently have the capability to create the SNP profile that we need for genetic genealogy. So there's a number of labs in this country that are doing this work now. So that DNA would be sent to them. They would create that SNP profile. So typically they're looking at anywhere from about 700,000 to about 1 million SNPs. There's three different processes they can use now. There's microarray, which is a SNP chip, which just looks at those. They can do whole genome sequencing, which looks at the entire genome and then extracts out those SNPs. Or they can do a newer technology called Kintelligence, which looks at far fewer SNPs. And then once that analysis is done, the scientists work with that file, with that data, to try to make that data more optimal, because typically we're working with degraded DNA, mixed DNA, contaminated DNA. So we need the bioinformatics scientists to work with it on many of these samples. Then once that is done, they upload it to GEDmatch and or Family Tree DNA, and it's compared against all of the people in those databases that are opted into law enforcement matching or not opted out if it's Family Tree DNA. Then we receive a list of people who share DNA with that unknown person we're trying to identify. We call them the subject. It's not always going to be the person that committed the crime. We've had a number of cases where it ends up being contamination from a law enforcement officer, or it's someone who was at that crime scene for an entirely different reason. And so it's really just our job to try to narrow down the DNA contributor's identity. Sometimes we can narrow it down to one probable contributor based on their family tree, and if who is related to all of these top matches that we get on that match list. And sometimes it's a set of siblings or cousins. Sometimes we don't have enough data to narrow it down, and we have to do much more work at that point.
CeCe, how does this flow chart work that we've put up here? Can you kind of explain
Sure.
what we're looking at?
So this was my most straightforward case to date. It was the very first one I worked with law enforcement. It was Jay Cook and Tanya Van Cuylenborg. You can see up there in the top corners. They were murdered in Snohomish County, Washington. They were Canadian residents who were down running an errand. And Tanya was raped, and there was a DNA sample on her pants. And so that was sent for this SNP analysis. A profile was created, uploaded to GEDmatch. We got really lucky in this case, and this is not typically what happens, but this is the most straightforward way to explain it. We had two matches at the top of that list who shared about 3% of their DNA with the unknown suspect. That means they are approximately second cousins. So I don't have to build the family tree too far back, just a few generations to find those common ancestors. Once I've identified those likely common ancestors with that person of interest, then I'm going to do reverse genealogy or descendancy research, where I build forward from those common ancestors, which you can see noted as great-grandfather, great-grandmother, and grandmother on this chart. And then I look for a triangulation or a union couple between those two family trees. Match 1 and match 2 are not related to each other. So our person of interest has to be related to both of those people. In this case, I found that a person from match number 1's family tree married a person from match number 2's family tree. And you can see them there as mother and father. They had 4 children, but 3 were female. And so there was only 1 male in that family who could be our DNA contributor. He is a cousin to match number 1. He's a cousin to match number 2. And we all have unique family trees except for our full siblings. So that meant that he was my theorized DNA contributor, but I can't tell them it's him because I don't have his DNA. So I'm presenting a theory or a hypothesis and saying, this is who I believe it most likely is based on the genetic genealogy analysis. Now, typically I would use a dozen matches or 24 matches, and they would be much more distant than this. We'd be building back to the early 1800s or 1700s. So this is a case that only took me 2 hours to find this individual because we got lucky. And so I gave you this chart because it's the easiest to explain, but usually we're going to be dealing with a lot more data, a lot more.
So applying what you just explained to Kohberger, because everyone's asking, I mean, listen, the DNA in that case bothers me, all of it. But everyone's asking this question, which is the identification of Kohberger. In other words, the genetic genealogy testing was the linchpin in that case. And then they found familial DNA from the trash they retrieved from his parents' home. And that's where they felt they hit the jackpot, and they were able to get the arrest warrant for him. And then, of course, once he was arrested, there was direct DNA from him collected. So my question to you is, what is the accuracy or margin of error in the science? Because I mean, this is a big issue in this case.
It's really different than when you're doing a one-to-one comparison where you get those numbers, like there's a 1 in 30 trillion chance that it's anyone other than this individual. We are not using that type of approach. We're just saying this is the theory of who this DNA contributor is based on their family tree. So there really isn't, it's not applicable or relevant to say there's a confidence level attached to that or a statistic, because I don't know it's him. I'm simply developing a hypothesis based on who he's sharing DNA with in the database and what their family trees look like. And
well, Jim, look, Jim, in the probable cause affidavit that the public defender, the law enforcement filed for Kohberger's arrest, they specifically said, do not rely on the genetic genealogy testing information in the affidavit. Essentially, the probable cause was supported by other facts.
Right.
So
I understand there, Sarah, that they, I guess they triangulated to the Kohberger family through this genealogy DNA research, and then they did a garbage search. They got DNA from garbage, and that it as close to a STR match as they could get to the father, and they matched that to the snap on the knife.
That sounds like a closing argument.
Yeah, I mean, so
garbage
I think
DNA. Garbage DNA.
I think that's what they did. Now, one thing, CeCe, that concerns me is, this is sort of in the background, and I know you say it's just for leads, but we know, doing the work that Sarah and I have done over the years, that if the law enforcement become focused too razor-like on one person, they're going to go out and build a case against that person.
Yeah.
They're going to stop following evidence and start building a case, and but
they can't do it without the exact DNA match, that STR profile match that's 1-to-1. So even if I were to point them toward the wrong person, say I think it's this guy, they have to go out and try to get that DNA to compare to their court admissible evidence before they move forward with any case. So if I'm wrong, they just won't get that STR match.
Well, I mean, I hear you, but they make criminal cases all day long without DNA evidence. I mean, they could.
Sure, they have.
Oh, by the way, this is what cracked the Golden State Killer case, isn't it?
It is.
Right.
But if they had not gotten that 1-to-1 STR match, they wouldn't have arrested him.
Right.
And so that, yes, there has, of course, been cases where they have arrested someone whose DNA didn't match the DNA at the crime scene. And I've actually helped to exonerate someone with in a case like that, which is, amazing. And one of the great things genetic genealogy can help do. But in this case, if we said, okay, we think he's your DNA contributor, I don't see why they would arrest him if they don't get the DNA match, because our work is all about the DNA. It's completely unbiased. I don't know anything else about him, or even typically when I'm working a case, I don't even know much about the case. My job is only to tell them who I think the DNA contributor is, but it's always a hypothesis until they vet that.
How much of your work is with law enforcement and how much of it is with the defense?
98% is, or maybe even 99 is with law enforcement. But the Innocence Project, Barry Scheck is very, very interested in genetic genealogy. So I've worked with him. There's certainly cases where we are trying to identify the true DNA contributor in order to help them exonerate someone. And
Barry's going to be a guest on the podcast. He's
great.
An old friend and colleague, and I know he's obviously a great authority.
Well, ask him about it, because he has really strong opinions how it needs to be used. He wants there to be a warrant anytime it's used. He's very, very strict about its use, but he also sees the great promise in it.
I do have a question, though, about the Kohberger case. Can you at all hypothesize what the triangulation was in that case? I know it's all hush-hush and we don't know much, but can you say, was it like a fourth cousin, a second cousin, or how distant the relationship may have been in that case?
Well, I, of course, wasn't involved in it, or I wouldn't be able to speak about it. So I don't have any inside information, but I have built his tree early on just to see how difficult it might be. Anyone who has recent immigrant ancestry in their tree is typically much more difficult to identify. And he is at least 3/4 Italian. Okay. And so I doubt he was really easy. They might have gotten lucky and got a first cousin, but that is very rare because the databases we use for this are very, very small. And so typically you're using, if you're lucky, second cousins, but more typically third, fourth, fifth, and beyond. And so I don't know, the FBI did the genetic genealogy in this case. I would suspect they worked with more than one match, that there were multiple matches, that they built back and found a common ancestor, and then built forward and tried to narrow it down. I doubt they had a lot of great matches based on his family tree. So there's some luck involved. It's just who has opted in, who's uploaded to those databases and opted in, and then what is the population group of the individual you're trying to identify. So I can't say what I think it was, but I suspect it wasn't easy and that they really had to work pretty hard.
CeCe, what databases do you rely upon to do your genealogy research? Is it all that's when people upload their DNA, or do you go to, independent or the Mormon Church or some other database?
That's a great question as well, because most people are under the misconception that we're really digging into the DNA. But really what matters to us is how much DNA someone shares with that unknown person. And from that, we can predict their likely relationship. From there, we're turning to public records. So we are digging in public records the vast majority of the time in our work. We're using anything that's available. There are billions of digitized records out there. Ancestry.com holds many of them. As you said, FamilySearch.org that the Mormon Church owns has many of them. There are smaller databases all over the internet and all over the world that we can use. So if I have to build a tree back into Norway, then I'm going to be using Norwegian genealogy records, which are online. If I am building a tree that's mostly based in California, then I'm very fortunate because California has a lot of public records that are available that some other states don't. So every state and jurisdiction has different laws that determine what records, vital records, are available, and some have a lot more than others. We use newspaper archives. We use social media. We use people search databases like, say, White Pages Premium, been verified, those types of databases. And so we're really using dozens of different resources, but they are all publicly available, and there's nothing that I can access that anyone else can't.
I have a question. Just generally, the database of where this is all coming from, is it really just a matter, as you said earlier, of just who's opted in? So it's just a bunch of like good Samaritans who've decided that they feel like they should upload their genetic info? Like Sarah mentioned earlier, my word is hesitant. I put on a little bit of a conspiratorial cap. It just seems odd to me that people are like, here, take my DNA. Like, what's the upside for people to be doing this?
Increasing public safety, getting violent criminals off the streets, behind bars. And a lot of people are also very interested in Jane and John Doe's getting their names back. And for those, there's about 40,000 individuals in the U.S. that have died without their identification. So there's a lot of support for identifying them as well. At GEDmatch, if you're in the database, you are compared against those. You can be listed as a match for those. But if you want to, but for law enforcement, for criminal cases, you have to check that box. And so everyone in GEDmatch can be compared against the Jane and John Doe cases. And only about a third of the database has opted into criminal comparisons. Now, as far as why people do it, I've been involved in some long-term studies about this. And I think you would be surprised at the broad support that we're hearing from the public for this tool. And most of them aren't actively supporting it. They're not putting their DNA in the database. And as I said, there's over 40 million people who already have this analysis done and could put their DNA in these databases, and they're not. So we don't know exactly why they're not, but we are definitely hearing a lot of support, even for identifying close relatives in their family, because they feel
there was a case. It's still going on in federal district court out of San Francisco. A Jane Doe sued the city and county of San Francisco last year because she was a victim of sexual assault in 2016, and they took her DNA for the purposes of the sexual assault exam and obviously to identify the suspect. And then unbeknownst to her, they saved her DNA in the database, and they then identified her as the suspect in a burglary.
Right.
So, I mean, as a defense attorney, I'm going to say, don't be a good Samaritan and don't opt into any of this, because it really is. I mean, she's claiming, unconstitutional use of her DNA, which obviously she has a good argument for that. Yes. But I just wanted to put that out there. It wasn't really a question for you, but
no, I mean, it's something I publicly spoke out against. And I also spoke out against using the newborn DNA for those types of purposes, because I strongly believe that people should have the right to decide how and if their DNA is used for these purposes. And that's why I really promote best practices and ethical use of genetic genealogy. It's really important to me that we're following the rules, following the terms of service, and only using the DNA profiles of people who have allowed them to be used. And so that's why I spent a lot of time educating the public. I want them to be able to make informed decisions as to whether this is something they want to support or not.
What do you think of the lab that they used in Kohberger in Texas, Othram or whatever? Do you know that one?
I do. They are one of the third-party labs that is capable of creating a SNP profile. They use a technology that is targeted sequencing. So my understanding is they're not doing the whole genome sequencing. They are targeting certain parts of the DNA and sequencing just those. And then, like any of the analysis used in genetic genealogy, they extract out those SNPs that we use for comparison. And those are chosen to be as comparable as possible to the files that the direct-to-consumer DNA testing companies create, because that's who we're comparing against. Mm-hmm. And so, they've been under the gag order. They haven't been able to speak out. But my understanding is that they created that SNP profile, but then it was sent back to the FBI Investigative Genetic Genealogy team. So they actually did the tree building. They did the work to try to identify a potential person of interest. And Othram just did the processing of that DNA. Now, because it's touch DNA, that's obviously more difficult, but we've had quite a few cases where we have also been able to work with touch DNA. But as you well know, as a defense attorney, you have to be much more careful tying someone to a crime when it's touch DNA, right?
Right.
Because we know.
And transfer DNA.
Right. And so as the technology becomes more and more sensitive, we obviously have to use more and more discretion as to whether that's actually tying someone to a crime. And that's why I emphasize my job is just to identify that DNA contributor. It's not to say someone's guilty. It's to say, I think this is your DNA contributor. Now you need to go do the investigation and determine whether that person is potentially your suspect or if it's just someone who left their DNA behind.
You basically generate a lead is what you do.
Exactly right. And that's why I haven't had to testify in court in front of a jury. I've been on hold in dozens of trials. But so far, the judges have all ruled that genetic genealogy work is irrelevant because it's not used as evidence or it's not used to charge anyone with a crime. And therefore, they haven't needed me. I have testified in grand jury hearings and pretrial hearings. But so far, the case law and the precedent that is being set in the cases I've been involved in is that the genetic genealogy does not need to be presented in open court in front of the jury because it's not used against that person.
Jim, I wanted to get you in here. It looked like you wanted to say something a few minutes ago. I can see you're burning to get in here.
I am. I have 2 points. One, though, people listening may not know the difference between touch DNA and other forms of DNA. So just touch DNA is if you, like the Kohberger case, I understood they took a cotton swab, perhaps, and swabbed the snap on a knife sheath, and that's where they got DNA from, and that would be touch DNA, correct?
Correct. Yeah, and we don't know exactly what was available and what they had to work with in this case, but obviously with touch DNA, there's a lot less sample available.
Right, and then others, semen, for example, that's a body fluid, and you get DNA from that, or hair samples, or tissue samples, and so that's a different type of DNA, correct?
Absolutely, and so that is going to help determine how directly it ties someone to a crime, of course. And I'm not an expert in this. I'm not a lawyer, but certainly we're working a case where they found semen inside a dead woman's body that has been raped. And, that individual didn't have any tie to that person, wasn't a known partner, then that's much more damning than if somebody's blood maybe is found on a wall at a crime scene, which we've had that happen, and it ended up being a prior occupant of that home. In fact, we've had that happen.
You agree that, like what Jim was saying, the touch DNA could be transfer DNA as well?
Absolutely. Yeah. And, I'm not a geneticist. I'm a genetic genealogist. So I'm just speaking from the work that I've done. But to me, as a layman, it seems clear that touch DNA is far less damning than when someone's blood is mixed with the blood of the victim or their sperm is inside a dead body. Sorry about being indelicate. But.
Yeah. No.
So, and the next question I have is there scientific consensus as to what it takes for a match in your field?
So a match in our field means something very different than a match in a law enforcement database or a court case. A match in our field is a partial match, and it's caused a lot of confusion, and I wish we had a different term, but that's what we've always called it in genetic genealogy. If I get a match, that could be someone who shares 1% of their DNA and is my third cousin, and we share a set of great-great-grandparents. That's very different than a match in, say, CODIS, where it's that person, or if you're doing familial search, then it could be their parent or child or sibling. And so that's very high confidence. There's no reason for two people to share 1% of their DNA unless they have a common ancestor or ancestors in their tree. And that's what genetic genealogy is based on. And so we're typically working with these very small amounts of shared DNA and very distant relatives.
Well, I mean, 99% of DNA is common to all humans, but you're only talking about 1% of the DNA.
Not this type. So this type of DNA, you share 50% with each of your parents, about 25% with each of your grandparents, about 12.5% with each great grandparent. And this is the type of DNA that changes quickly. SNPs, single nucleotide polymorphisms, are the ones that mutate, that change. And so those ATCs and Gs are going to be different with people that are unrelated. And we're looking for long identical stretches. We're not looking for single marker matches like you would with the STR profiles. Yeah, and so it's many in a row. They're actually blocks of shared DNA.
And that really is my question. How many in a row have to match before it's a match?
So we measure them on centimorgans. That's the unit of measurement for genetic genealogy. And if somebody shares, I would say it's not an exact science. 20 centimorgans or over is pretty confident that they have to have at least one common ancestor in their family tree. The match lists typically go down to 7 centimorgans, but we're not typically using those. We are usually using maybe the top 12 matches or top 24. We're hoping we'll find matches that share over, say, 70 centimorgans, which is approximately a third cousin. If you are sharing anything above 50 centimorgans, we can be confident that you are going to have a relatively recent common ancestor in your family tree. As it gets less and less, it becomes less confident. But as I said, down to about 20 centimorgans, it's highly confident you have someone in your tree that is the same, but you might not be able to find them because maybe they're way back in 1595.
Right. And is that, CeCe Moore's standard, or is there a textbook? Is
yeah, that's a good question. So genetic genealogy was developed by citizen scientists. It's not something that academia or forensic science or traditional scientists were really interested in until we started using it for law enforcement. So there is not a lot of published material, but there are a few studies that talk about the confidence levels and how far down you have to get in that centimorgan count before it becomes questionable. And so there's some that say 14 centimorgans, but 14 centimorgans still can come from so far back that I really kind of err on the side of 20 centimorgans. But yeah, that is my, as the person who's done more genetic genealogy than anyone in the world, that is my standard. But I don't have a science degree. I mean, that's genetic genealogy. You can't get a degree in. There's no licensing. There's no certification. There's no accreditation yet. And so that's one of the reasons that if genetic genealogy were brought into court, it would be very difficult to validate it. It's science and art. It's not something where we're saying this is absolute. We are saying this is what the analysis has led us to develop as our hypothesis. And of course, all science is hypothesis, but this is a very different type of science, which is why it would be very challenging and why it should never be used as evidence against somebody.
Well, I do want to address this in the context of Kohberger. I keep going back to Kohberger because people want to hear about this. There is and I understand, a feud between the defense and the prosecution over the IgG in this case.
Which is typical. It's happening.
Yeah, so the defense is saying, we want to see the genetic genealogy testing and report, et cetera, that identified Kohberger. And the prosecution responded to that request for discovery saying multiple things about, like what you said, it doesn't negate his guilt. It is not material to the defense. It is not intended for use at trial, which I don't never like that argument, because just because you're not going to use it doesn't mean I don't want to, I can't use it. So, and none of the documentation sought belongs to the defendant, and belong is in quotations. Can you explain for our listeners why they're putting that in quotations? What do they mean it doesn't belong? I mean, they took touch DNA and they tested it and found this, what you call a match in your world. How is it?
Matches. So I read what you sent me, and they're asking for the names and the addresses of all of the matches. That would be typically thousands of matches, because you include those very distant ones down to, say, 7 centimorgans. Mm-hmm. And so that seems like, asking for much more than is relevant.
Yeah.
Now, I can see them asking for the ones that were used in the analysis. So
right.
like I said, maybe a dozen, maybe 2 dozen were used in the analysis to lead to that hypothesis.
So why can't the defense have a more limited number that was used? I mean, this is...
Well, I'm not a lawyer, but I know what case law has been so far. And there was a ruling in a California case that was appealed and upheld that ruled that they were genetic informants. So they were treated like confidential informants. And they really emphasized the importance for those people's identities to stay private. And we can understand why, because if someone were to get off that was actually guilty, right, then they would know which of their relatives were partially responsible for their identification. And that would obviously have a huge chilling effect on anyone providing their DNA for genetic genealogy purposes.
I want this to go up to the Supreme Court at some point.
I really thought that it would. I spoke in front of a lot of federal appeal judges last year, and many of them approached me and told me they don't think it will ever get to the Supreme Court. There was even 2 Supreme Court justices there when I spoke.
CeCe, could you give us, whenever you get a chance, you could text it, the case name or whatnot of that California ruling? I'm very curious as to.
Yes. I almost sent it to you right before, actually, because it is so key. And it was one of the very early trials of somebody that was identified through investigative genetic genealogy.
Yeah, it'd be great. I'll post it for viewers as well. So, Jim, do you have anything else for CeCe today?
No, CeCe, it's been very informative, and I really do appreciate you coming.
It's my pleasure.
And I think we need to talk to Barry Scheck. I mean, we were planning on talking to him, but talking to him about how he views what you do, helping overturn wrongful convictions, and on our side, obviously.
Yeah, there's been a couple of them now. The Angie Dodge case that I worked out of Idaho Falls was the first, where Christopher Tapp was formally exonerated finally. And so that really is the highlight of my career. I mean, it's the best use of this technique. So we'll hope there's many more.
And that's why we do what we do. So we appreciate you, CeCe. Thank you so much for joining us.
Thank you. It's so important to get this information out. So thank you for covering it.
And Jim, until next week.
We rest.
We rest.